Hearing for appeals to state of Michigan is now in session. The Honorable James Robert Redford, the Honorable Michelle M. Rick, and presiding the Honorable Michael F. Fidola. All persons having business herein draw near, give attention, and they shall be heard. God save these United States, the state of Michigan, and this honorable court.
Good morning.
Good morning.
Well done. On behalf of my colleagues, Judges Redford and Rick, welcome to the Michigan Court of Appeals. This is day 2 of our Detroit case call. This is panel 2. I'll let the lawyers know, as I always do. We know the facts of your cases. We've had reports from our staff on all the cases we'll be hearing today. We've read your briefs, so we're well familiar with the facts. You don't need to belabor those. Just try to cut right to the most decisive legal issues and let us know as succinctly as you can why you think you should prevail in your appeal today. In cases involving minor children or protected individuals, doesn't look like we have any at 10 o'clock, but in any event, don't use proper names, initials only. These proceedings are being digitally recorded.
What's that, Grandpa?
And will be uploaded, yeah,
like
on
when you-
cassettes.
On the phonograph.
Is that
You-
Betamax or, anyway, uploaded. to
I'm the
YouTube.
oldest one here, so I can see these.
Yeah. Within the next 24 hours. It's hard to get away from that terminology. Recorded, I guess that's the right word. Okay, with that, I'll call the first item on today's docket. It's item 17, docket number 370330, People of the State of Michigan versus Anthony DeRay Ben. And is Mr. Skinner on Zoom? Yes. So, and he is not endorsed, but we did make allowance for him to appear to answer any questions we may have. Mr. Skinner, you're here. I'll let you put your appearance on the record, and then we'll see if anyone has any questions for you.
Thank you, Your Honor. Michael Skinner on behalf of defendant appellant.
Any questions for Mr. Skinner?
No, but thank you for the brief. I thought it was very thorough and very well done.
Thank you, Your Honor.
And I'll come back to you after our Applebee's counsel makes her argument to see if we have any questions for you as a result of your opposing counsel's argument.
Morning, Your
Very
Honors.
good.
I'm Ready, Assistant Prosecuting Attorney, appearing on behalf of the people. I believe that my brief covered most of everything, and I'm happy to rely upon it and take any questions.
Any questions for Ms. Ruddy?
Same comment. Thanks for the brief.
Thank you.
Okay, thank you. So Mr. Skinner, I'm guessing we don't have any questions for you.
That's
So,
fair, Your Honor.
very good.
I
Thank you.
appreciate you letting me show up.
Yeah, absolutely.
you.
Appreciate it very much. The case is submitted. All right, that takes us to item 18, docket number 370909, People of the State of Michigan versus Scott Richard Shemansky.
Morning, Your Honors. Michael Frone on behalf of Mr. Zemansky. And it appears you have a really busy docket today regarding issues 1 and 2. I don't have anything to add to the brief. I know the court, when I do that, has read the brief and understands that I'm not retracting any argument. I asked for a new trial on behalf of Mr. Zemansky on issue 1, but I don't have anything to really add. So regarding issue 3, if the court reaches issue 3, first, I want to say I appreciate that, opposing counsel confessed error on that and agrees that a remand has to occur. That's appreciated. But I think the disagreement would be, what's the remedy? I would ask the court to consider just remanding for a resentencing. This actually came up recently in the room down the hall. When the court asked questions, should we remand for resentencing? Should we remand? Like the prosecution's arguing to give the judge another chance to add reasons and so forth. People v. Stinson, I think I have that right. I'll give you the number 370424. Court wants to look at how they resolve it. It's interesting. I like this judge. She's always polite when I appear in front of her. She does like to exceed the guidelines, but she's always been polite. She's always listened to my arguments. And this is the same judge. Same judge we had in Stinson, same underlying offense, departure, etc. I'd ask the court to remand for resentencing because I think it'll save time. If you do that, and if Mr. Stinson feels aggrieved he can appeal. It's an appeal by right. Because the underlying conviction is a jury conviction. If you don't remand for resentencing, give the alternative, the judge probably is going to make another, in Stinson, we had to go back, 3 times and eventually we got it resolved. But I think it saves time to send it back for resentencing. I think that if you look at, People v. Steenhouse, from our Michigan Supreme Court, they do state, quote, if the Court of Appeals, it's sort of a gray area what the remedy is here, but the Michigan Supreme Court did state, if the Court of Appeals determines that the trial court has abused its discretion in applying the principle of proportionality by failing to provide adequate reasons for the extent of the departure sentence imposed, it must remand to the trial court for resentencing. And that's what occurred here. If you don't, and if you send it back and give the judge the alternative, I would hope the court, this is why I bring up the Stinson decision, I would hope the court would retain jurisdiction because it's an appeal by right. And if you send it back, don't retain jurisdiction and the judge just gives more reasons, then I think he could be stuck with an application. Well, that's not fair because this is, it's an appeal by right and the court needs to review the sentence by right. And so I would ask the court at least, retain jurisdiction. But I hope the court gives some consideration to skipping that and just remand for resentencing.
May I ask a question?
Sure.
Do you think it's, if we were to agree that it has to be addressed, is it a vacation of the sentence and a remand, or is it a reversal and a remand?
Oh, it's an interesting question. Vacation of the sentence, I would call it. I don't think it, as a practical matter, I guess I'm not sure it would matter to the
Yeah,
defense.
I'm not sure it matters. We have that in a couple of cases, potentially this month, and I'm just trying to sort out what the best mechanism is.
I think the Judge Redford's hit it on the head there that we do kind of struggle with that. And what we've seen is that if we reverse and remand, speaking from my own experience, it might suggest to the sentencing court that they just need to put more of an explanation on the record to justify the original sentence imposed. Whereas if we vacate, then clean, it's a clean slate, if you will.
Well, I've never thought about it that way, but that would make sense. Obviously, then I would prefer the indicated that to vacate the sentence and not indicate that they only need to put more reasons.
Right, no, and I've been on panels that have sent it back and said, you need to re-articulate or impose, within guidelines.
Either way, I think procedurally, and by the way, and again, I always have to pause and remind myself, really, on behalf of Mr. Zamansky, what he would really is issue 1 is the main
Yeah, he
issue.
wants to have the conviction set aside. So.
But I think either way, procedurally, if you do reach issue 3, it would, I think it would be better to remand for a resentencing. I haven't really thought out thoroughly of this issue of how you phrase that. I'd have to go back and look, but I guess I haven't really thought about that until today very, very deeply. So, okay.
Any other questions for
No,
Mr. Ferrone?
thank you.
All right, you'll have time for rebuttal. And Mr. Miller, even before you get started, you may have gathered that we're interested in this sentencing issue.
Yes.
So you might want to lead off with that.
Yes. Good morning, Your Honors. May it please the court, Assistant Prosecutor Joshua Miller from the Oakland County Prosecutor's Office on behalf of the people. I will lead off with the sentencing. I will leave issues 1 and 2 on the brief unless the court has any specific questions for me after I address the sentencing issue. As Mr. Ferrone mentioned, it feels like a little bit like deja vu because he and I were both on the Stinson case.
Oh.
It was the same, as he mentioned, the same sentencing judge, same underlying charges. And so frankly, I don't even disagree with him necessarily as to if resentencing is appropriate in this case, because unlike Stinson, there was at least something on the record.
And we don't see any reasons
and
given.
My read of your brief is you're basically conceding error on that issue.
Yes,
Okay.
we are here. The sentencing judge, with all due respect, just she talked about the guidelines and then nothing about the mandatory minimum.
Sometimes judges forget to say what they're thinking. Okay,
Yeah.
I've been there.
Yes. And so whether it is a remand for further articulation or a full resentencing, obviously from prosecutor's perspective, we don't like necessarily having to bring the victim back in, especially on a crime like this, given that it was clear the trauma she had suffered from this. But If it is necessary, then it is necessary. So we will leave the remedy to the court's discretion.
Okay. Any other questions for Mr. Miller?
No, but thank you very much for also confessing
Yeah,
error.
Yes.
That's huge.
When there's an error, we have to acknowledge
There
it.
you
What's
go.
your
It's-
position on, oh, sorry.
No, go ahead.
Nope, I remember from that benchmark conference, we have to, like that guy from North Dakota said, respect the point. So you're on, you're going, so.
I was just going to say it's easy sometimes to not think about those very finer points of our practice. And it was you did some great modeling.
Thank you.
Thank you.
Thank you.
What do you think of Mr. Ferron's request that we retain jurisdiction if we send it back?
I do believe that that would be appropriate. That's what happened in Stinson on the first go around. So that when the court made further findings, then they came back. It just seems procedurally like it will move things along faster.
Okay,
Thank
very
you.
good. Thank
Thank
you.
you.
Anything else, Mr. Ferron?
No, just to be clear, I just want to, if you do remand it for a resentencing period, you don't need to retain jurisdiction. But Stinson, what happened was they did send it back with that alternative. You can, to the trial judge, articulate further reasons or rescind.
What's the
Oh,
difference?
oh.
What's the difference? Why would that matter?
Well, because if it went back, once it goes back for resentencing's held, he can appeal that by
It's an
right.
appeal.
Right.
There's no reason to train. So if you send it back for a
I see.
sentencing period, not the alternative, just directing the trial judge, you have to resentence, then you're done with it.
Okay.
Okay,
And we have no complaints about that. Also, I'll say, by the way, regarding the victim, it's an interesting comment, but I will say, if this happens, if there's resentencing and the victim doesn't show up, you're not going to hear from me that the judge can't consider, the.
Right.
Okay,
I was
good. I
thinking
think
about
everyone knows
that myself,
Yeah.
that, well, you've got sworn testimony. Is there
Sure, I'm
or
not
if
gonna-
not sworn testimony, you have in-court testimony.
Right.
The defendant was present with counsel. There's no
That's all
confrontation problem.
fair, that's
Okay.
all fair consideration to consider that. Thank you.
all right. Thank you very much. I appreciate you
Yep.
refining that point. That's helpful. All right, the case is submitted. Yes, okay, good, yeah. Item 19, that docket number 372959, which is State Farm Mutual Automobile Insurance Company versus Philip W. Leonard.
Good morning, Your Honors. Daniel Campbell here for plaintiff State Farm. Before I begin, I'd just like to reserve the majority of my time for rebuttal since this is a pretty straightforward case.
Sure.
This case arises out of a declaratory action that was filed at the Wayne County Circuit Court against the City of Detroit, Mr. Philip Leonard. The Wayne County Circuit Court's a court of general jurisdiction, so it had the jurisdiction to declare that State Farm did not owe PIP benefits for Mr. Leonard. And it also follows that it had the jurisdiction to declare that State Farm was entitled to reimbursement from the City of Detroit for payment of the no-fault benefits that it owed. The court has any questions for me, I'm happy to answer them. Otherwise, I will yield my time to the City of Detroit.
Yeah, I mean, it seems to me your lawsuit is premature. Because this, we're talking about, this is a police officer, right?
Correct, Your
Okay, yeah. Yeah, this might very well be a comp case. It kind of looks like it is to me, but I'm not sure that was the call of the circuit judge to make. So, the issue. If you want to address that now, you can
Yeah,
feel
absolutely. Your Honor.
free, but
In State Farm's motion for summary disposition, we addressed the priority statute, MCL 500.3114. And specifically, we argued that that statute applied because the officer was in a City of Detroit vehicle. He was employed with the City of Detroit at the time of the accident. Therefore, that was triggered to put the City of Detroit in priority for PIP benefits over State Farm.
okay. What if in the administrative proceeding, they disagree, then what? I mean, I don't have much doubt that this is a comp case. I just think we may have put the cart before the horse here. That's my.
Well, Your Honor, respectfully, with regard to the comp case is actually irrelevant to State Farm's claim because this is a PIP claim that State Farm is seeking reimbursement under and a declaration of priority. In that instance, regardless of whether the comp case, finds either way, the accident under 3114.3, it's that he was in the furnished vehicle on the date of the accident and he was an employee,
Is
regardless
that
of
the
that.
sole relief you sought in your complaint?
Well, our complaint sought a declaration of priority.
Right.
Also sought reimbursement. And there was mention of workers' comp, but at the time that the
Right.
complaint was filed, we only knew of the workers' compensation action. So we filed the complaint to make sure that we could discover further facts
Right.
on the issue.
But in your prayer for relief, you're asking a trial court of general jurisdiction to give relief for something that is statutorily and constitutionally reserved to another fact-finding and decision-making body, right?
That is correct, Your Honor. But after discovery, after the discovery responses were received, we took Mr. Leonard's deposition. We filed the motion for summary disposition, asking for the relief that was further honed on the discovery in this case.
Did you voluntarily dismiss the paragraphs of your complaint which sought relief from another, that only another tribunal had authority to give?
State Farm did not voluntarily dismiss anything in that
Oh,
complaint.
okay.
That is
So
correct.
if you didn't, and as a matter of black letter law, the trial court didn't have authority to give you the relief that you sought, why were you entitled to summary disposition?
Well, at the hearing for summary disposition, the focus was on whether or not the city of Detroit was in priority. We argued they were in priority. At the oral argument, we argued they were in priority and that State Farm was entitled to reimbursement. Further honing that down, it was simply put, State Farm did not owe. And with that, there was no arguments made about workers' compensation whatsoever as, oh, State Farm is entitled to this. If there was, State Farm would have taken the position of, hey, we need to amend because allowing the complaint to be amended is freely given. So at that point, there was no mention of it. So State Farm proceeded with the information based on discovery and the deposition that the city of Detroit was the priority insurer for payment of no-fault PIP benefits and that it was entitled to reimbursement.
So would it be fair to characterize your argument this way, that you were seeking a declaration that in the event there are workers' compensation benefits available, your client would be entitled to a set off?
With the State
So
Farm's,
it's sort of forward looking, I guess.
I see. I
In
see
the
your point, Your
event
Honor.
that a determination is made that he is entitled to comp benefits, then we get reimbursement for what we paid out.
But State Farm would get reimbursement from the city of Detroit because they are also a self-insured no-fault carrier. And they're
Right.
also
Hey,
workers'
I don't
comp.
care who the money comes from.
So in that instance, State Farm is just seeking subrogation reimbursement of PIP because Mr. Leonard would have to seek workers' compensation first from the city of Detroit, then no fault, and then State Farm would have to ask through the no fault carrier, city of Detroit, for reimbursement.
You happen to know what the city's rationale was for denying the claim initially?
We did not know, and that was one of the reasons State Farm filed the declaratory action.
Yeah.
State Farm sought information, and by filing the declaratory action, we wanted to get more information, suspecting that, this would be a priority issue and that there would be subrogation, but we didn't know that at the time the complaint was filed.
I have another. On
Yep.
March 22nd, 2023, shortly after the complaint was filed, did the city provide State Farm the necessary forms and documents to intervene in the police officer's underlying work comp claim?
That is correct, Your Honor. They
Did
did.
State Farm ever seek to intervene?
State Farm did not seek to intervene.
Why not?
In this case, State Farm sought to have the question of priority. As we pled in the complaint, we pled 500.314 or 3114 as priority. We sought to use that as the relief because if we intervene in the Workers' Compensation Board, the Workers' Compensation Board does not have jurisdiction to decide priority under the No Fault Act or decide subrogation under the No Fault Act. So in that instance, yeah, we would intervene, but it would be kind of fruitless for State Farm to seek the relief that it sought in its declaratory action.
Counsel, I'm looking at your prayer for relief, though. You asked for a determination that an actual controversy existed and that Detroit, and then parenthetically, you say workers' compensation is responsible for payment of any and all benefits, et cetera. with exception, and then any other relief granted. That seems inconsistent with what you've just
And
explained.
inconsistent with how I characterized your argument.
And I can see that because at the time that the complaint was filed, we didn't have any further information other than there's a workers' comp claim. That's why we pled notice with, this is 3114, that this could be an issue of priority. But after further discovery and with the MSD, our prayer for relief changed based on the facts that was found out in discovery.
Problem is, as Judge Rick helpfully points out, in the prayer for relief in the complaint, you ask the circuit judge to make a determination that this is a comp case.
Mhm.
That's different from saying, well, our real prayer for relief is for you to declare that if it's a comp case, we're entitled to set off. Those are two different things.
And yes, I understand that, Your Honor, except for the notice of the rights and the duties of the parties in the prayer for relief, also in the body of the complaint of what duties and obligations that State Farm had under the No Fault Act, I think is very important because we didn't know what the duties and obligations of State Farm were at that time. So filing the complaint based on what we knew, we changed the prayer for relief later when it came to the motion for summary disposition.
Any other questions?
Thank
All right.
you.
All right, thank you.
Very
Your Honor.
helpful. Thank you, counsel.
Morning, Your Honors. Patrick Cunningham on behalf of the City of Detroit. I think the panel has identified the exact issue here. The prayer for relief in this complaint is to ask the circuit court judge to make a determination about the status of the workers' compensation claim. The circuit court doesn't have jurisdiction to do that. We have a couple of cases saying that the insurance company has the right to intervene in the comp case if they want a determination of their rights with respect to the comp payments. Good news is the comp case continues. There's a hearing set in January 22nd. I brought a Form B if council is interested in it, that they can still intervene in the comp case. That's all I have unless the panel has questions for me.
Any questions?
Yeah.
No, I don't think so.
Thank you.
Any rebuttal, counsel?
Just a brief rebuttal, and I promise it will be brief. I think the clear point that State Farm makes here is that, yes, they could intervene into the workers' compensation case, but that does not provide a venue with jurisdiction to determine the order priority and subrogation. And that's why State Farm brought the declaratory action, and that's why we're here today.
So sort of the same point in reverse. The comp case wouldn't be the proper venue in which to determine the priority issue. Is that what you press told us? Yeah, okay.
Chief, I do have a question.
Yeah, sure.
Discovery is completed in the underlying litigation.
Correct.
Did you provide the city request to admit?
We did.
Did you ask them to admit that they were the first priority for no fault and PIP coverage?
We did not ask that directly, but we asked
I know.
requests to admit that built up to that to show that they admitted that they were a self-insured no fault carrier. They admitted that they owned the vehicle. They admitted that that was a vehicle that was involved. So connecting those facts, that is exactly it. The same admission, but through several requests to admit rather than one.
Okay. All right.
All right. Thank you.
Thank you
Your
very
Honors.
much. Case is submitted. Well argued. Interesting.
Yeah, it was interesting. I will admit, I didn't think it was going to be as interesting
Right.
as it was when
As
I
it turned out.
started it. No, what's this about? Then, but it was well briefed, well argued.
All right. That brings us to item 20. Docket number 369632. Jeffrey Eisenberg versus George W. Kuhn Drainage District. And I think we'll hear from defendant appellant first. There's a cross appeal, right? So the way I typically like to do this, I think it's most efficient. He'll argue on behalf of appellant. Appellee will have their usual opportunity to respond on the main appeal. At that time, you can argue your cross appeal. All right, then you'll have rebuttal on your appeal, and you can respond to the cross appeal at that same time during your rebuttal time. And then I will give appellee cross appellant the opportunity for rebuttal on your cross appeal. Does that make sense to everyone? Okay. Are you dividing time, or we have an hour for this case? So I'm sure we won't need it, but You can proceed.
Good morning, Judge Godola, Judge Rick, Judge Redford. My name's Scott Petz. With me is my colleague, Oma Sobo. We're with Dickinson Wright, and we represent the Drainage District, the George W. Kuhn Drainage District. And given the format just announced by Judge Godola, it's my understanding I'm going to limit my initial comments to count 2, which is the unjust enrichment count that the trial court did not dismiss based upon our C8 motion. What are we asking for? What is the Drainage District asking for as to the unjust enrichment count? We are asking for this court to enforce pleading standards, to look at the elements of an unjust enrichment count, in particular, the enrichment, the retention of a benefit. And in doing so, we believe that this court should reverse the trial court on its failure to dismiss the unjust enrichment claim because the elements were not pled. Going to keep these comments very brief because as to this issue, you have the application briefs and you have the appellate briefs. By my count, it's over 70 pages of briefing on one element of unjust enrichment. So plaintiff's complaint does not contain factual allegations that show the Drainage District has retained the GLEWA bill funds at issue in this case. The GLEWA bill funds at issue in this case are also referred to as the Water Authority charges. The Water Authority is not the Drainage District. The Water Authority is GLEWA. Further, when you review the complaint, you review the briefing, I believe you will agree that plaintiff concedes that the Drainage District passes through the GLEWA bill funds it receives from its member communities and gives them to GLEWA.
Here's what I see as the problem with your argument. It would effectively, I mean, not in every case, but nearly every, it seems to me, eliminate any potential claim for unjust enrichment. Hypothetically speaking, so long as the party that was unjustly enriched spends the money. How can that be the law? I mean, you can only successfully plead and prevail upon a claim of unjust enrichment if the wrongdoer takes the money that it took cautiously and puts it in the bank and lets it sit there. But if they do anything, if they spend that money, they buy a new house, a new car, then that defeats your claim. Because that's what you do. You should call it a pass through. But this was money that your client owed, it seems to me, to the recipient of the funds. I mean, if you hadn't passed the funds through, then what happens? So I don't see how you get around that.
I hear what you're saying. I would ask that in reading the briefs, you look at the Ganson case, you look at the Corey case, you look at Liggett, you look at AFT, you look at the body of law on what it means to plead the elements of unjust enrichment, in particular element 2, the retention of the benefit. This is not a case where someone received money and then used them for their benefit to go buy something. And the funds were thus transferred into something that is of value to that. This is not someone receiving funds, going out and buying a car and saying, aha, I got you. No retention of the benefit. That's not this case. What we believe is that plaintiff must allege facts demonstrating that the Drainage District has profited or enriched itself with respect to how the Drainage District interprets GLEWA's bills and distributes them to the Drainage District member communities, Royal Oak, Troy, for payment, and plaintiff does not. In fact, they're suing for $7 million that they know was passed through to pay the GLEWA bills. The GLEWA bills.
Right, but counsel, if the underlying proposition is correct, that your client is not using the correct manner of determining what their bill should be. And let's assume just for a moment that the bill is $50, should be $50, but you're billing $60. Let's assume that that's correct, because and that you send them a bill for 60, they pay 60, and then you put 60 to the GL Great Lakes Water Authority. Okay. You shouldn't have had 60 to put in. You should have had 50 if you would have billed it properly. So their theory, as I understand it, is the 10 extra on that $60 bill that you took from them to pay your $60 bill from the Great Lakes Water Authority, you would have had to get that 10 from someplace else. And that's why your client was unjustly enriched. They were able to transfer funds in payment of the full bill from Great Lakes Water Authority that they alleged you charged them incorrectly. How do you have to make, if it's true, how are you not responsible to have to make that up?
Okay, I hear the question. The GLEWA bill relates to the drainage district service area. The communities
Right.
in the drainage district service area include Royal Oak, they include Troy.
Well, they
The
include
drainage
a whole
district-
bunch of other places too.
Oh, they do. They include Clawson, include Oak Park. And the drainage district gets that bill, it interprets that bills, and it distributes it to the member communities, Royal Oak, Oak Park. They then look at the bill, decide how it should be addressed. And as to Royal Oak decided that they were going to collect money from its ratepayers. That money then goes back to GLEWA, or back to the GWKDD and what is called the GLEWA bill pool. And that pool is not overfilled by how the drainage district allocates the GLEWA bill. Rather, that
But
pool is
counsel-
given to GLEWA. We
counsel,
do not have the
step-
funds.
Stop, please. Step back to your client, the drainage district sends to the municipalities the bill and says, here's how much Royal Oak, you're responsible for 29.7% of the bill or whatever, it was, somewhere in that ballpark, I think. Their position is you're overcharging them by a substantial amount.
Whose position is it, Your Honor?
The plaintiffs.
The plaintiffs meaning the resident ratepayers of Royal Oak. So they believe that their municipality that represents their interests is addressing the bill incorrectly by asking them to pay for it, and instead should be challenging through the political process with a little p, the petition process, not suing us for money we don't have.
No, that's not what I meant to say, or I'm not trying to say that. What I'm asking is, do you believe well, let me ask you that. Do you believe that the plaintiffs in this lawsuit have alleged that you're charging the wrong amount of money to them?
We don't charge the plaintiff residents. We charge the communities. The communities, through the process that it works through with the drainage district, decides how to address that bill. So if the residents have an issue with how their community is addressing the GLEWA bill, which we all know is the drainage district getting the GLEWA bill, interpreting and distributing it to communities so it can fill up the GLEWA bill pool with the funds that it gives to GLEWA, and that's conceded. I'm not understanding how the residents can then sue the drainage district for the GLEWA funds that it does not have.
Are you saying they should have sued the city instead, or could have equally as well sued the city?
The court is well familiar with a Kickham-Hanley 2019 case and a 2021 case in which they sued the city.
I am familiar.
And you were on one of the panels,
was.
Judge Redford.
I was.
And
I think I was too.
okay.
Yeah.
And you know, I can't tell you who they have a cause of action against. What I can tell you is that when I look at this complaint, they have not alleged a cause of action against the drainage district in this instance as to the GLEWA bill funds that are at issue, because those GLEWA bill funds are collected and remitted to GLEWA in whole. The distribution and interpretation process is not to be enriched by plaintiff residents.
Your client doesn't decide how much the ratepayers are charged, in other words.
The Royal Oak will decide how it addresses the distribution of the GLEWA bill given to them. In this case, Royal Oak decides to give it to its residents, recover the costs, give the money to us, and we then put it in the GLEWA bill funds pool, which is not overfilled by our interpretation and distribution process, and given to GLEWA. GLEWA is ultimately the party that gets the money. And as I indicated, they're basically wanting to second guess the whole rate making process. And who they're saying has really benefited would be, for example, Troy, because they're saying that they had too much of the GLEWA bill put on the storm side instead of the sanitary side. So they overpaid for their portion of the GLEWA bill funds, whereas Troy has the exact opposite. Sanitary is higher than storm. And it's nitty gritty. You got to read the briefs. I know you have. I would ask that you be open to this idea that retention of a benefit does matter. You look at Ganson, you look at Corey, you look at other cases. This is not your typical rate case where they're suing, for example, a defendant saying, you charged me something that was unconstitutional. You charged me something that's in violation of a statute. You got the money and you used it for your benefit. This is literally the drainage district getting a bill from GLEWA for the benefit of the drainage district communities. You have the drainage district look at that bill, interpret and distribute it to the communities in the first instance, and the communities decide how to address it. If communities have an issue, they can work through a resolution process, a petition process. This is not a case where you take millions and millions of dollars from a drainage district that serves communities, which has residents, and leave it paying money it has appropriately passed on to GLEWA. And I do ask you to look at the Kickham-Hanley 2019 and 2021 case. And that case, what you'll see, there was a bit of a scheme going on. In the Royal Oak case, I believe what happened on the lower court is that the court actually dismissed the case on MSD. And then there was a motion for reconsideration. It was pending for like a year. And then a settlement was reached. And what happened is Royal Oak paid Kickham-Hanley some money related to a debt facility charge that has nothing to do with our case, and then gave them the right to stand in the shoes of Royal Oak with Kickham-Hanley, the law firm, as their trustee to sue the drainage district related to the GLEWA bills. But in doing so, the residents had released any and all claims they had against Royal Oak. Royal Oak had passed through all the expense, all the funds received to us. And I'm telling you, we passed on all the funds to GLEWA. So I can't tell you who they can and cannot sue. What I can tell you is you cannot sue a party without meeting the elements of unjust enrichment. And in this case, they have not met the elements of unjust enrichment, period. I mean, if this case is decided where the drainage district interprets and distributes bills to communities, and the communities decide to address it in a certain way by recovering fees from its residents, you could have resident 1,000 or resident 2,000 saying, my house or my business is different. You shouldn't have charged me like the others. And so Royal Oak, because you did that and you passed the funds on to the drainage district, you can sue the drainage district, even though the drainage district passed those funds on to GLEWA. I mean, you are allowing the whole billing process to be upended. When you look at these types of cases, it involves the governmental agency having a charge for its own use, for its operation of its own system that is illegal under the Constitution. Look at like the bond case, illegal under a statute. Look at yellow freight, look at coal, and you can't charge for what they're charging. And they receive the money directly from the plaintiff and they use it. I mean, how is GLEWA ever going to bill drainage districts? There's many drainage districts that they bill. And they're taking into account many factors. They're taking into account GLEWA debt, settlements in other cases that they may have had with Kickham Hanley where they're attacking the GLEWA rates. All of that gobbledygook gets thrown into a GLEWA bill that gets distributed to a whole bunch of drainage districts. My client, a drainage district, got that bill. And it has a resolution, which is not a contract, it's not a statute, it is not a constitution. And it interpreted and distributed those charges to the drainage district communities in the same way as to all, using percentages of storm and sanitary, and the communities received it. The communities process it. There's discussions that occur.
I'm not sure this is necessarily relevant to anything, but I'm just curious. You've said on a couple of occasions that it's up to the municipalities to decide how to raise the funds in order to pay the drainage district's bills. Is there some way other than to do it other than what they did here, which was to go back to the residents, business owners, home property owners, and charge them individually? Is there some alternative way to raise that money?
I believe there is. I mean, they could pay it out of the general fund and say that they are contesting the bill and not going to charge the residents, for example. But the more likely example would be through the petition and apportionment process and through the political process with a little p, because the communities and the drainage district and its residents, meaning the community's residents, are benefited by the GLEWA bill being paid. If the GLEWA bill is not paid, that's going to hurt services to the drainage district, to the communities, and to the residents. And I would submit to you that allowing residents to not address it with their city, whether it be through political or some other means, to then jump to the drainage district, knowing full well that the drainage district passed on the fund, the GLEWA bill funds pool to GLEWA, and that's what they're doing. They just don't like how it's being distributed. It's not that we're taking access as a whole. It's not that we are being unreasonable as a whole. They just don't like the math. I mean, you read their paragraph, their 85 paragraph complaint, and they are literally putting on their rate making hat and saying, on behalf of a plaintiff in Royal Oak, this is how I want the GWKDD to do things.
Is there a statutory or contractual way that one can challenge the GLEWA bill that your client could or the municipalities could?
There may be. I've not looked into that, Your Honor. I can tell you that plaintiffs counsel.
Short of just filing a lawsuit.
Yeah, I can tell you that plaintiffs, there's discussions that occur.
Well, in Kickham, the court wrote the following, quote, under MCL 280468, the drainage board was required to apportion the costs for the drain on the basis of benefits accrued to each benefiting public corporation. And under MCL 280478 parent 1 and 280478 parent 2, the drainage board was required to make an apportionment of cost for any necessary expenses incurred in the operation and maintenance of the drain. As a benefiting corporation, Oak Park had the opportunity to object to the drainage board's apportionment of costs. MCL 280469.
Yep.
Okay.
Oak Park, Royal Oak.
So that's the answer.
I think that is the answer.
Well,
I think.
Well,
Yeah.
let me ask a
Go ahead. I'm
question.
sorry, Judge Rick.
Thank you. I want to, this is very complex, and so I'm going to rely on your expertise, and this may not be entirely relevant to our conversation, but just to follow the logic as it relates to the claim of unjust enrichment, I understand your position in terms of being a pass-through entity, if you will. What happens, or has it happened, where GLEWA has not been fully satisfied? And to whom do they look? Is it the drainage district?
Yeah. I mean, it is a good question.
Oh, good. I'm glad.
Yeah. I mean, I'm unaware of such a situation as I stand here at a podium. Basically, GLEWA has charges. Those charges are thrown out to a whole bunch of drainage districts,
Right.
whether they be in Detroit, Wayne County, whether they be, I believe, in Macomb, whether they be in Oakland County. And Oakland County has many, many different drainage districts, right?
So with
Maybe, but they-
respect to yours, is
Go ahead.
what I want to know is what if you don't satisfy that pot?
That's a problem.
And, okay, and then what happens? That's
That-
my question.
That would impact everyone downstream. It would impact the drainage district. It would impact all of the communities, and it would impact all of the residents, just as it may impact all of the residents, all of the communities, if this court ordered the drainage district to pay money that it retained, when we all know it didn't, the GLEWA bill funds, pay GLEWA bill funds it retained that it doesn't have because GLEWA is satisfied.
May I ask a question?
Yes.
I don't necessarily want to go to my $50 and $60 example, but let's assume for a minute that your district, I mean, just flat out gets it totally wrong. And you charge 70% to one municipality and the other 15 municipalities that are participating in the sharing of the bill get the remaining 30%. The outfit that got 70 should have only been charged 50% of the cost. Is there any remedy for the municipality or the residents of the municipality who were charged way more than they should have been charged if that took place?
Is there a remedy against
District.
I mean, when you say any remedy, I mean, when the GLEWA bills are allocated to the communities, which is over 10, there is an,
Sorry.
which is over 10, I think it's 14 communities.
Right.
There is an opportunity for a dialogue with the communities. The communities are working together to satisfy the GLEWA bill funds that are required. They're working together. They all have an interest.
Everybody wants fresh and clean water.
Exactly.
So-
And I believe that the Royal Oak residents do as well.
Right.
And if the GLEWA bill funds were not satisfied,
Go ahead.
that would be in jeopardy. And I do want to go back to one thing with your citations to the final order of apportionment process. That is how a resolution becomes there. And a resolution is not a contract. This court has held that. A resolution is not a statute. It is not a constitutional provision. And there's percentages set forth in that resolution, and those percentages are being followed. The allegation is rather.
Hold on.
Go ahead. I
Are the
apologize.
percentage, no, don't apologize. We appreciate your enthusiasm. Does the percentage, does this chart that has the memorialized percentages that are going to be sent to each of the municipalities, is that promulgated in a public manner before it's adopted by a public board?
Yeah, look back to the 2005 resolution final order of apportionment, and I think you'll find your answer to that. I think the answer is yes. And the percentages as to what your sanitary contribution percentage will be and what your stormwater contribution percentage to be is set forth in that resolution. And it's used as a guide by the drainage district to distribute the GLEWA bills. Now, can I say one other thing?
How do you decide Royal Oak gets 29% and, Redford Township
Yeah.
gets, gets 10%?
Yeah, I actually really appreciate Judge Rick saying this is complex because I'm talking about one element of a cause of action, right? But it's complex. The subject matter is complex. And so the allegation in this case is not that the wrong percentages from the resolution were applied to Royal Oak, meaning the wrong stormwater percentage or the wrong sanitary percentage. And that's where I think you're talking about 29. I think there's a 19. And we set forth like how, for example, what they're really alleging is Troy benefited because they underpaid. But regardless, there's a pool of GLEWA bills and the drainage district figures out what part of that pool is storm, what part of that pool is sanitary through the resolution process and working with the communities. The communities get the bill from whatever they owe for the pool after applying their percentage to the storm side of the pool and the percentage to the sanitary side of the pool. And they're not saying that those percentages were misapplied or miscalculated. What they're saying is that we think more of the pool should be sanitary and less of the pool should be storm, and thus Royal Oak residents, we want to pay less. And they're saying that Royal Oak, I guess, should not have accepted the bill. Oak Park shouldn't have accepted the bill. Troy shouldn't have accepted the bill. And they should have said, no, this is unfair. And should have, I'm not sure what, but ultimately the communities assess the bill received. They figure out how to recover it. In this instance, Royal Oak believes in the bill and recovered it from ratepayers. And the ratepayers paid into the Gliwa bill pool. The percentages from the resolution were not misapplied, and the Gliwa bill pool was given to Gliwa. We don't have a pool of money to swim in. We don't have a pool of money that was used to go buy a house, Judge Godola, to your
Right.
point.
You can't sell the house and then pay the judgment, right? Because you don't have the house.
'Cause-
You've already paid the money out. So I made a note here, where would the defendant get the money to pay plaintiffs because they paid the Gleeville bills?
Well,
So
and ta-
you
and
don't
take a-
have the funds any longer.
And take a look at the cases in the rate world. Like, you're gonna see that these cases involve like blatant situations where someone charges for books, receives the money for books, even though the Constitution says they can't charge for books. Like, this is not that case. This is literally the drainage district doing what is necessary in accord with a resolution that's not a contract, not a constitution, not a statute, it's a guide, working with communities, filling up the pool and giving it to Gliwa. Gliwa has the money. And I hope that the court will keep that in mind when it's re-reviewing the application and the appellate papers. I know you guys have read everything. I appreciate the questions.
Not you guys, Your Honor.
I apologize. I apologize.
That's fine.
Judge
Counsel.
Godola, that is an appropriate
Yeah.
comment. I apologize.
Don't do that before
Tremendously.
Judge Letica either. She'll,
Okay.
yeah, gavel you down. We've run you up to 26 minutes of your 30. So you obviously need time to respond to the cross appeal, which I don't think should take very long, but also rebuttal on your main appeal. So why don't we leave it there for now? And if we have additional questions, we'll get to them during your rebuttal time.
Judge Godola, I appreciate that. As I get older, I wonder if
Oh,
Very
my
old.
I wonder if I get tired faster. You telling me you spent 26 minutes
Yeah,
makes me understand why I might be a little tired. So
All right.
thank you. Thank you.
okay, thank you.
Older. My gosh. What's your P number? 7.
7-0.
Mine starts with a 3, brother. So,
Mr. Hanley's is lower than mine. So-
Yes.
you're probably
Good morning, Your
higher.
Honors. As an aside, I almost went to the wrong table. I'm usually not over here.
Right.
So I appreciate that opportunity. Greg Hanley on behalf of the plaintiff. I'll try and match Mr. Petz's enthusiasm and still keep it under my time. A couple things. This is a rate discrimination case. In other words, it's a bedrock principle of utility rate making that you can't charge similarly situated customers differently unless there's a difference in cost associated with servicing people. So we've used this simple analogy in our briefing, but it's really apt in this case. If you had a street that had 5 houses on each side, and that was the only thing that Gliwa was providing services to, and the county couldn't go down that street and charge only the people with the odd addresses and not the even addresses. And then say, well, even though we didn't overcharge in the aggregate, yeah, we overcharged you, but we gave all the money to Gliwa and therefore nobody has a remedy.
So as I've started to think about it, I hate to cut you off so
No problem.
quickly, but as I've started to think about this, as your opposing counsel, Mr. Petz, was making his argument, I start to think of it in terms of who was the proper defendant here. I understand the nature of the claim. Ultimately, shouldn't it have been or be Gliwa?
No, because.
Okay, why not? Because they're the ones, I mean, it is. true,
Gliwa
they're-
didn't overcharge. That's the real basic fact that needs to
So
be
it's a
understood.
misallocation.
Here's what
claim,
happens.
Right?
Yep, there's a misallocation. Gliwa bills the drainage district about $50 million a year.
Okay.
Okay, then the drainage district has,
This specific district.
right.
Okay.
And then they have to part that out in two ways.
Mhm.
First, they have to split it between stormwater
Right.
and sanitary.
And
Okay,
then
so they take that
municipality.
50 million.
By
Now-
municipality.
This is a C8, it comes to you as a C8. So everything
Mhm.
we say, well pleaded facts in the complaint have to be taken as true. They mess it up in two ways. First, everybody knows, well, this is a really important fact. The GLEWA calculates these rates every year. And the rate maker, that used to be a guy named Bart Foster. And this bill that they get from GLEWA to the drainage district,
One person decides the rate.
one person decides the rate. It's got to be approved by the GLEWA board, but one person's done it. He's done it for years. He did it for Detroit. In any event, that's a whole different ball of wax. But what they do is their first task, once they get this $50 million bill, is to say, how much are we going to put in storm?
Yep.
And how much are we going to put in sanitary?
Right.
Okay. We know that about 30% of the total flow to the district is stormwater. And then the rest is other stuff, right?
Mhm.
They allocate more than 50% of that GLEWA bill to the stormwater side, inexplicably, even though GLEWA has a methodology that is published every year in a cost of service study that says, that enables somebody to say, how much of my $50 million is for stormwater? Okay. It wouldn't matter if all of the communities, that this is the second parting out, is now, once they split it into those two buckets, they then have to allocate it to the 14 communities.
Yep.
Royal Oak residents, our clients, pay more for stormwater than they pay for sanitary. 29%, as Judge Redford pointed out, for stormwater. And if they were charged the same percentage for both, it wouldn't matter how the drainage district parted out the bill, because they would just, Royal Oak would get 20% of the total bill. But because they parted out, and because Royal Oak has such distinct percentages of each one, the more they allocate to the stormwater charge, the more Royal Oak people pay. Okay, so we have no beef with GLEWA. We have no beef with Royal Oak in this case, because the argument or the allegation is not that Royal Oak is taking this and screwing it up as it bills to the people.
Mhm.
Royal Oak's bill is about $1 million higher from the drainage district every year than it should be because of this misallocation.
How does that happen mathematically? I guess I'm having a little trouble wrapping my head around why this discrepancy
Okay,
charge-wise between
let me
stormwater.
try and make it simpler.
Yeah.
Let's say they build $10 million to Royal Oak, okay? For the whole kit and
both.
caboodle, for the whole
Yep.
kit and caboodle. And that's because they're putting too much in the stormwater bucket and too little in the sanitary bucket, okay?
That drives the bill.
Because of the
up.
difference in percentages. So let's say I'm Royal Oak and I get 29% of the stormwater charge in the aggregate.
Storm is higher or sewage is higher?
Storm water is higher, believe it or not.
Yeah, why is that?
Even it's nonsense. And we've pointed this out for 10 years and no one does anything. And we lost the Kickham-Hanley cases. The Kickham-Hanley cases are very instructive and very favorable to us here, because my law firm was trustee but we got our claims from Royal Oak. And what this court said in the Royal Oak Kickham-Hanley case and in the Oak Park case is that it was the residents who were harmed. And in both cases, they said, this court said it, and this is from the Royal Oak Kickham-Hanley case, while the retention of the alleged overcharges collected by GWKDD may have resulted in an inequity to the ratepayers, Royal Oak suffered no loss, because Royal Oak got the bill and they recaptured that bill from their residents. So this case is not about a beef with GLEWA. This case is not about a beef with the city. And the Kickham-Hanley cases collectively hold that it's the ratepayers who have the cause of action. I mean, it didn't explicitly say it, but But by excluding the cities themselves from having the ability to sue for this, they necessarily recognize that it's the rate, because the money, this is from the Oak Park case, because the money at issue belonged to Oak Park's ratepayers as opposed to Oak Park itself.
So do you dispute the entirety of the bill or just the apportionment? Because I asked that from the perspective of where is the unjust enrichment? I mean, it sounds like the bill is the bill.
The bill from Gliwa to the drainage district is the bill. Okay.
Right.
It's how they take the $50 million and allocate it to the various communities that is the problem.
So when Mr. Pett says we just pass through that revenue to pay the bill, therefore we can't possibly be unjustly enriched.
Well,
Your response is?
my response is the Supreme Court and I think it's pronounced Kachik, begins with a T, but it's a binding published Supreme Court precedent where it defines unjust enrichment in a way that's uniquely applicable here. It says, even when a person has received a benefit from another, he is liable to pay therefore only if the circumstances of its, and these are important words, receipt or retention are such that as between the two parties or the two persons, it is unjust for him to retain it. And so what that destroys, that one sentence destroys both of their primary arguments, which is they have to retain it. No, they either receive it or retain it. And it, the panel's questions have illuminated this, but it would be, it would destroy the law of unjust enrichment for a defendant to just get rid of the money somehow.
My opening point.
Right. It's the receipt or retention. Okay. That's what the Supreme Court says. Can't read the word receipt out of the ruling. And then it says, as between the two persons. So the person in my example who pays double because they just happen to have an even address, they got value for their first half of their payment. That was their sewer usage. They should pay that. There's no question that there's unjust enrichment, that there was no unjust enrichment from that. But when they had to pay the second half to subsidize the others, that is the measure of the unjust enrichment. So the notion that you can evade responsibility, what they're trying, and we'll get to the assumption, but they're really trying to navigate between a Scylla and Charybdis. They got the rocks on one side, which is unjust enrichment, and then they've got Assumpsit, the whirlpool, on the other side. And what they're essentially saying is, we get through this, and it doesn't matter how we apportion this. It doesn't matter that people in Royal Oak paid to dispose of Troy's sewage, because that's essentially what's happening here. Is when you overcharge Royal Oak, you're necessarily undercharging others. And so,
can I ask a question? When in this process, temporally, does the determination of what municipality is going to get what percentage, when does that take place?
that has not taken place in 25 years. It goes back to the year 2000. And this is a really important thing about this resolution that Mr. Petz was talking about. We embrace the resolution. We say they're breaching the resolution because all the resolution does is say Royal Oak has to pay 29% of the stormwater and 19% of the sanitary sewage. It doesn't say how that is broken up or apportioned. And it's at that stage where the problem lies, is that, yes, Royal Oak should pay 29% of the stormwater, of the real stormwater charge, right? Which is much lower than what they're apportioning. And because they only get 19, and let me answer your question first. These percentages are determined on the stormwater side based upon land area and impervious surfaces, all that stuff.
Yeah.
The sanitary is based on water usage, which is
Right.
the water usage in this community.
Because
okay?
everything's metered. There's no septic.
There's a master meter that at the edge of this drainage district that measures every gallon that goes through and enters what's called the DeQuinder interceptor to come all the way downtown to the treatment plant, right?
Yep.
So everybody knows how much that is. So what the drainage district has to say is, okay, we've got 1 billion gallons of this stuff. And we're getting charged $50 million for that 1 billion gallons, okay? The critical component here, the essence of this case is you, drainage district, have to take the $50 million bill and split it up into these two buckets, okay? And that's where they are doing it wrong. And we know they're doing it wrong. Again, this is the allegations of our complaint, because GLEWA provides information sufficient to allow the drainage district to know to the penny how much they're being charged for stormwater and how much they're being charged for the rest. Okay. So we get to this situation where all they really are arguing here, and we've had a long argument, but it's really boils down to this. Does the fact that it's a net zero thing, that they take the collective money from these 14 communities and give it to GLEWA, is that legally sufficient on the facts alleged to defeat a claim for unjust enrichment? And the Kachik case answers that question in our favor, because you don't look at as between the drainage district and the world, you look at as between the two persons, meaning the residents of Royal Oak and the drainage district. Would it be more fair to allow the drainage district to continue to overcharge forever, or to provide a remedy that is a well-recognized remedy in the municipal utility rate-making area, right? And a lot of the unjust enrichment cases get to the merits in this area, but this court is really given a unique opportunity to deal with it in this very particular context, meaning you're overcharging some so that you can undercharge others. And if you can't have unjust enrichment, you have no remedy.
In the 2021 case, with Judges Forthood, Kavanaugh, and Tuckle, they talked about that statutory process that I read that section of the opinion to Brother Counsel when he was providing his comments. My question to you is there a point in time throughout this process that you or those you seek to represent could have come in and said, hey, this isn't right. You're not doing this correctly? Is there an administrative rules, statutory?
There's nothing that I'm aware of that would allow the people we're purporting to represent to come in, and other than just having everybody can go to a city council meeting for 3 minutes, right? But this process of setting this is done all above the from the community level, municipality level on up, right? This is not Royal Oak.
Are there public meetings where these are addressed?
Are there public meetings where
These rate decisions are addressed?
I do not think that the drainage district has meetings. I mean, first of all, GLEWA has meetings, but we don't quarrel with anything GLEWA did. The quarrel is with what does the drainage district do with this bill when it gets it? There's nothing that I'm aware of that would allow somebody who's a ratepayer in a community to come in and upset that apple cart.
Okay. If you're being overcharged, who's being undercharged?
The communities who have a higher percentage of sanitary than storm, because if you put more in the storm, you're putting less in the sanitary bucket. So a place like Troy, and I don't want to get too technical, but the reason there's a storm charge is because, like in the city and up the Woodward corridor, which were all developed before 1950, they had combined sewer systems. Okay. If you're out in Shelby Township, this is not an issue because your community was developed with a separate storm system, right? Which goes to a river.
In the drainage district, how many have separate systems?
Well, it's more complicated than that. Some cities have both. Some cities have a little of both. Troy has a little of both. So it's not necessarily done by community boundaries, but it's fairly complex. But think about if you drive up Woodward all the way to Pontiac and you go 2-3 miles on each side of Woodward, that's basically what we're talking about here. Okay, so
The vast majority of the unitary drainage system.
some of them do, but Troy is Troy comes to mind because it's got a large area that has separated systems. So Troy gets a higher percentage of sanitary than they do storm. And
When you say get, they're billed more.
they're billed more
Okay.
for storm than they are for their Royal Oak is billed more for storm than they are for sewer, but Troy's the other way around.
Right.
Because there's not as much stormwater coming from Troy, right? So
There's
if
not as much non-pervious
that,
space.
that may be the same, that's probably true as well. But the percentages go back to studies that were done in 2000. I don't know how valid they are, but we're not challenging that in this case. We're not challenging the 29% or the 19%. We're challenging the nominal amount of money that gets put in each bucket that ends up resulting in the overcharges.
All right, I think I'd like to move on to your cross appeal.
Yep.
And if my colleagues have questions on the main appeal, feel free to
Well,
ask those, but hasn't assumption been abolished as a cause of action in Michigan?
it's been abolished as a cause of action, as a freestanding cause of action. So the question becomes, what's left, right? That's what,
Unjust enrichment. Right?
well, but I'm not trying to be flip about it, but the cases are a little bit all over the map on this. Everybody says it's abolished. Oh, wow, that's great. But let's read the very next line of Fisher Sand, which is that notwithstanding the abolition of assumption, the substantive remedies traditionally available under assumption were preserved. And they say, Supreme Court, binding published, if a cause of action is stating in the complaint showing the pleader entitled to relief, the appropriate substantive remedy will remain.
Right.
So we know that there have been assumption cases after 1964.
I think it's just a labeling issue, to be honest with you.
Well, what Yeoman says is it's a subset of unjust enrichment, right? But if you look at the elements, I'm not willing to concede
Sure.
that assumption is subsumed within unjust enrichment, because assumption applies regardless of unjust enrichment if the original retention or the original receipt of it was improper, or if equity and good conscience dictate that it should, as between the parties, it should be given back.
Yeah.
So the problem with thinking about it being subsumed, the Corey case is a case from, it's unpublished, but it's from 2016, where this court dismissed or upheld the dismissal of an unjust enrichment. But then they said, our opinion today addresses conversion fraud, statutory conversion, unjust enrichment, and due process. However, we note that a claim to recover fees paid to the state in excess of the amount allowed under applicable law is properly filed as an action in assumption for money had and received. So they said, oh, if you would have pleaded that, we would have kept you in court, but you didn't plead that, and we're not gonna give you the benefit of that for purposes of this. But they cite the bond case. And so what assumption comes down to, we argue, is, first of all, there's something left of assumption. There's no question about that. And what is that? What it is you can't just have a freestanding claim for assumption. You have to tie it to some substantive right, okay? In bond, they violated a constitutional provision that said you had to provide free public education, and they were charging for textbooks, okay? Assumption was this post 1964, assumption was the remedy, but the Constitution was the source of the substantive right, okay? Here, the source of the substantive right is the common law reasonableness requirement that applies to municipal utility rates, okay? And we can get into presumptions and all the other stuff when you get into the substance of the claim. But the reality remains is that if they violated the common law, a sumpsit is a remedy that has traditionally been available and remains available. And for that reason, I mean, with the easiest way to deal with all of this is just to say we have an unjust enrichment claim, which we do. And then maybe you don't have to decide whether, if you don't have an unjust enrichment claim, can you still have an assumpsit claim?
Okay.
But for all those reasons, we'd ask that the court reverse the denial of our assumpsit claim and affirm the ruling upholding that fact that we have pleaded, again, C8, pleaded a claim for unjust enrichment.
Okay, thank you. And you actually will have a little bit of time on your cross appeal if needed. So, Mr. Betts, and again, your time here is limited, so just be aware. Got about 3 or 4 minutes left.
Understood. I want to say, GLEWA does not tell the drainage district how to allocate the GLEWA bill to its member communities. And I believe I heard Brother Council indicate that what the resolution does is it tells you how much percentage of a storm bucket and how much percentage of a sanitary bucket.
Each community will
It doesn't tell you what's going to be in the bucket, Your Honor. Sorry to interrupt.
Yeah.
It doesn't tell you how much is going to be in the buckets. It tells you the percentage to apply to it. That's what the final order of apportionment does. And it is a combined system. So this idea that a Royal Oak may have a higher storm contribution percentage to a bucket versus a Troy that's more separated, and Troy has a higher amount that they have to contribute to the sanitary bucket, they're saying that's not an issue. They're saying that's not an issue. They're saying that the bucket, like how the buckets are filled is the issue, not the fact that the storm percentage is higher than the sanitary percentage for Oak, or in Troy, the storm is less than the sanitary. So when you're looking through those allegations, I ask that you look through them very carefully. I do think it matters that the drainage district does not retain the GLEWA funds. And I reference you to our briefs, Michigan Supreme Court decisions, appellate decisions. Enrichment matters. The use of the funds matters for your benefit. And in this situation, these funds were received and provided to GLEWA. There's no allegation that the way the drainage district was interpreting or distributing the bills was done to enrich them. And I think that should matter. In terms of, I believe, Judge Redford, you might have asked a really good question of like, well, couldn't you sue GLEWA? That thought has crossed my mind. I think that she. Okay, I apologize for that. I'm doing really well here. I say you guys, which I will never say again.
Redford never would have thought of that question.
Well. But I kind of just want to jump to a sumpsit at this point. And, with a sumpsit, we have the 2021 Yeomans case, it's published. We have the 2023 Midwest valve case, which is published. I believe Judge Rick may have been on that panel. We have the Allen case, which is published. That's a 2024 case. A sumpsit as a cause of action has been abolished. And I did hear Mr. Hanley refer to something about like a common law reasonableness as to rates cause of action. I'd ask this court to read the case law very carefully. When you look at rate cases are brought for constitutional statutory violations. You're looking at Headley. You guys have seen, your honors have seen these cases. I've jinxed myself now. I apologize. But even when you go into bond, for example, and you'll see it on page 12 of our reply brief, as this court explained in Yeomans, an action under bond will not lie against one who has not been personally enriched by the transaction. We've not been enriched, and it is element 2 of unjust enrichment that requires dismissal, and a sumpsit cannot be used as a substitute to essentially keep the case alive. I mean, that goes against 3 published Court of Appeals decisions.
Okay, I think we get it. Anything else?
Well, thank you.
Thank you for your argument.
Thank you so much,
Appreciate
Your
it.
Honors.
Mr. Hanley, any rebuttal on Assumption?
No, Your Honor.
I didn't think so. All right. Thanks very much. Very interesting case, very well argued and briefed. This one may take us a while, but we'll get a decision to you as soon as we can. Thank you for your arguments, and the case is submitted.
Thank you.
All right. I am wishing, even though we're not quite at the end of our 10 a.m. call, so my apologies to the lawyers who were here for item 21, but I think we'll take a 5-minute recess right now. All right, we are back for item 21, the last on our 10 a.m. call. Docket number 373757, Nader Korani versus American Select Insurance Company.
May it please the court. Good morning, panel. My name is Chris Filiatro, appearing on behalf of the plaintiff Nader Korani. Your Honors, just as an aside, I want to thank the court. I apologize. I filed my appearance yesterday because Mr. Banka, who's our appellate lawyer at the firm, was in the hospital. So he asked me to
Sorry,
cover
guys.
this. He's
Okay.
okay. He'll be
Good.
fine. But unfortunately, since this was a relatively narrow issue, I felt I could cover it.
He
without-
trusted you. to cover
Just
it.
as to me, and such. So as long as the court doesn't go into 50 years of standing or real party
Okay.
interest, I think I'm fine.
All right.
But
You
I'll
never
do my
know.
best.
Judge Redford really takes deep interest in those issues, so.
Great finding, especially.
Right.
As we all do, and such. So, Your Honor, from reviewing everything, and I'll make it as short as I possibly can. I will not re-argue everything that we put in our briefs. The only thing I will add, though, is that the trial court's decision was based on the Wallace case. And the Wallace case has since been decided by the Supreme Court after our briefings were submitted. We apologize in that I know I've spoken with Mr. Sangster on it, who's a friend and a fine lawyer and such. And so I think we're going to be kind of devolving into this Wallace discussion a little more today, probably, than what was briefed. But I think from reviewing Wallace, Your Honor, the Supreme Court Wallace, I should say, the Supreme Court case, it basically turned the Court of Appeals decision backwards a bit and just basically came out with a new ruling, which says in this scenario where you have an assignment, when you have revocations and rescissions and claims of that sort of thing, this one they sent back to the trial court, which is Judge McCarthy, which happens to be a judge in our case as well. So and so in that Wallace case, they sent it back for determination whether or not it's going to be a rescission issue. And if it's a rescission issue, that is one avenue that you can basically is void ab, it makes the contract void ab initio, and then therefore they would be the real party in interest, and then the assignment wouldn't have any bearing, on the case. However, if it's determined to be a revocation, that's a different scenario as well, at least under the law. So at least my position, Your Honor, is that from our facts, which are basically identical to the Wallace case, we have an injured patient who then has an assignment with a provider. It's on all fours with basically the Supreme Court's Wallace case. So unfortunately, I think it has to go back down to Judge McCarthy, and she has to make a determination as to those issues of the rescission. And if rescission is available, then we have the equitable balancing that she has to do pursuant to the Supreme Court Wallace decision.
As a follow up from one of the questions I asked earlier, should we vacate or reverse and remand, or vacate and remand? And, in light of Wallace, we vacate and remand. I just don't know. Or maybe we should affirm. We'll talk about that, but
Sure, Your Honor, I guess the best advice I guess I would put out there to the panel is that if we follow Wallace, just follow what Wallace did for the Supreme Court, and I think they vacated it and sent it back down.
that's true. It's hard for them to reverse us if we do exactly what they did on this.
That's also true.
It could happen.
It could.
If I'm on the panel, it could happen.
Yeah, find a way.
Understood. So unless there's any questions, Your Honors.
Any other questions? All right,
Thank you.
thank you. You have time for rebuttal.
Thank you.
Good morning, Judge Goodall, Judge Redford, Judge Rick, and Ron Sangster for defendant Appley, American Select Insurance Company. My friend, Mr. Filatro, is right that the briefing in this case was completed prior to the Supreme Court's decision. I know in Appley's brief on appeal, we specifically alluded to the fact that the court had heard oral argument and that we were expecting a decision sometime before the end of the Supreme Court's term on July 31st, 2025. The decision came out July 3rd. I don't think it's as clear cut as brother counsel says it is. Yes, in the Supreme Court's decision, the court did essentially vacate the Court of Appeals, this court's decision in Wallace, but it did so under rather unusual circumstances. And it essentially ruled that if what the medical provider did was a rescission, then it had to be sent back down to the circuit court for balancing of the equities test based on Bozzi versus Sentinel Insurance Company. The court seemed to indicate that if it is a rescission, then yes, it restores matters to the status quo ante. It is as if the assignment contract never existed, and therefore that restores the ability to pursue payment of the medical expenses to the injured plaintiff. But question then becomes whether or not that rescission of that assignment contract is binding upon an innocent third party, namely the insurance company, who had nothing to do with the assignments in the first instance or the revocation of those assignments. So that's why it was sent back down. The court seemed to indicate that if it's something else, like a revocation, then perhaps the claim is still barred. That's why the court sent it back down, saying that even though the plaintiff's real party and interest status is restored by virtue of the revocation, disavowal, rescission of the assignments, that still does not mean that recovery is warranted. It can still be barred by the 1-year back roll. So in this particular case, I read the affidavit that was executed by Northland Radiology, which is a known player in the no-fault world. And frankly, I can't tell what it is. Perhaps that's a reason that will need to be explored on a remand. But it certainly appears that, again, I'm not, my guess it's probably a rescission. And if it's a rescission, yeah, it may restore matters to the status quo ante, but you've still got to do a balancing of the equities test. So in answer to Judge Redford's decision as to what probably should happen, yes, an affirmance, fine. I think,
You'd be okay with that.
I'd be okay with that. But I don't think it's a reversal. I think it's more of a vacating and remand for reconsideration in light of the Supreme Court's decision in Wallace. But I'm happy to answer any questions the court may have. I know I see Judge Redford there with a copy of probably the syllabus of the Supreme Court's decision.
No, but
No,
I've got other things.
Okay, that's fine. I just thought I saw something like this up there.
Pertaining to this case.
Right.
Oh, yeah.
I-
Oh, yeah. I'm still a paper file guy, and I think it's however many years I have left to serve, it's probably going to continue since my eyesight seems to get worse. So,
Yes, I mean, I've got the Supreme Court decision here. I highlighted and tabbed it.
oh, yeah. No, that looks like you raided my cupboard.
Any other questions for Mr. Sangster?
Okay. Thank you very much.
Any rebuttal, counsel? Okay, thank you very much. We appreciate
Hope
your
your
arguments.
colleague gets discharged.
Yeah.
Give our best to Mr. Banko. We enjoy seeing
Thank
him here.
you.
Okay, that case is submitted. That brings us to our 11 a.m. call, it now being 11:45. I'll just remind the lawyers, we know the facts of your cases. You don't need to belabor the facts. Just cut right to the most decisive legal issues. Let us know as succinctly as possible why you think you should prevail in your appeal today. With that, I will call the first case on our 11 a.m. docket, item 22, docket number 371303. Oakwood Ipsy Limited Partnership versus George M. Nyman. And defendant appellant is not endorsed. Attorney Holtz may appear to answer questions for appellant. So I'll let you put your appearance on the record, assuming you're Mr. Holtz, and we'll see if anyone has any questions.
Thank you, Your Honor. Ethan Holtz for the appellant.
Any questions for Mr. Holtz at this?
Not at this
No,
time.
not at
but
this
Okay,
time.
I'll ask my colleagues
Very-
again after we hear from your opposing counsel if they might want to hear anything from you.
Thank you, Your Honors.
Oh, you bet.
And good morning, Your Honors. Matthew Smith appearing for the plaintiffs and appellees.
Before you proceed, these are consolidated cases, so I will also call docket number 372294, same caption as the other docket number.
Thank you, Your Honor. Would you like Mr. Holtz's appearance again?
No.
Good morning. I will first off respect the admonition of Judge Godola and my wife who appeared before the panel yesterday to be brief and not repeat myself. And what I'd like to do is start off with a couple points that are in response to the reply brief that was filed by the appellants. On the first issue concerning the grant of summary disposition on the claims for declaratory relief concerning the validity of the amendments to the agreements of limited partnership, we start with the baseline of sections 12.2 and 5.4, both of which require the consent of the majority limited partners, the plaintiffs at police, to go ahead and to amend any aspect of the terms of the agreement's limited partnership, including their terms of existence that's expressly set forth in section 2.4. What we see in the reply brief is a lot of weight being shifted to the last sentence of section 5.4 by appellants, which grants the general partner permission to act, and I quote, if the existence or exercise of the right of consent or approval under this section on the part of the limited partners would impair the status of the partnership as a limited partnership under the act. And I submit that doesn't mean what the appellants are urging it to mean. What that means is if there was something to occur that would render the partnerships no longer qualifying for limited liability protection as a limited partnership under the act, then the general partner would be permitted to go ahead and act if for whatever reason he could not obtain the consent of the limited partners. It doesn't mean that the fixed term of existence agreed to in section 2.4 can be ignored and that the general partner can act to go ahead and extend the term at his will against the consent rights of the majority limited partners. And I think if you play that out practically, there's two examples and reasons under the law why you couldn't do that or accept that interpretation. Is the first, it would render nugatory the express provision that states the term of existence for the limited partnership, and it would also negate a number of the consent rights that are expressly granted to the majority limited partners within the agreements and limited partnership. As a factual matter, also in 2023, when all three of these amendments to the agreements and limited partnership were signed by Mr. Nyman and the other general partners, there was no threat to two of the statuses of the limited partnerships. We have Brunswick that was going to expire at the end of 2026, and we have Oakwood that was going into 2034 in its state of existence. There was nothing, if you accept their interpretation, that would allow them to jump in and act at that time as they did. As it pertains to issue 2, which is the appointment of a receiver, I think that's well briefed. If the panel has any questions, I'd be happy to accept them and answer them as best I can. As to the lis pendens or the motion for relief from judgment to file a lis pendens, again, it's an abuse of discretion standard. They state it's de novo. I disagree with that, and I cite the authority in our brief for that. And if you look at the statutory basis upon which a defendant who asserts a counterclaim can file a lis pendens, and that's MCL 600-2711, it requires a request for an affirmative judgment affecting the Title II or the possession, use, or enjoyment of the real property. They have a claim for breach of the limited partnership agreement, requesting money damages. There's nothing there that affects title to property, and I don't believe the trial court abuses discretion in denying the motion for relief from judgment. So unless the panel has any questions.
Any questions?
Yeah.
Okay, given my confusion over my oversight with respect to the consolidated case, did I ask you to give your appearance? Or, yeah, I assume you're Mr. Smith.
Oh, yeah, Matthew Smith on behalf of the appellees. I believe I did, though, Judge.
Yeah,
Thank you.
and yeah, we see your wife here quite regularly,
Yes.
as
yeah.
you know.
Yes,
And
I-
she of course did her usual splendid job yesterday, as we indicated to her. So
Well, thank you very
happy
much,
to
Judge.
see you. I think I don't know if it's the first time I've seen you here, but pleasure to have you appear.
Thank you so much, Judge.
All right. Any questions for Mr. Holtz?
I do have one question. If we were to accept your proposition, is there anything that keeps the general partner from extending in perpetuity the existence of the limited partnership?
I don't believe there is, and I believe that's the intent of the document, and it makes that expressly clear
But
in the
why, then,
language.
if you had that, then why do you ever have an expiration date?
Well, I believe per the LLC or the Limited Partnership Act, a partnership does have.
Yes,
an
they have a
expiration.
required shelf life.
Correct. And what the document says is in 12.1A is that the decision to do that is in the sole discretion of the general partner. And it's consistent with the nature of a general partnership in which the general partner makes all the decisions.
How much money did the general partner have invested in the partnership?
As the general partner or as a general partner and a limited? All in, I think he's 20%.
And the majority limited partners had the remaining 80%?
No, there's Richard Roth, the attorney who drafted the documents, I believe has, I want to say 7%. There's an individual named David Horton, who I think he has a lower percentage. And I believe the majority limited partners are not a majority themselves. As Mr. Roth testified in his affidavit, the Appley Limited Partners were a syndicate.
My recollection of the record is they have like 20 million or something involved. Is that incorrect?
Those numbers would be really high considering this investment was made in more than 30 years ago.
So, but your position is
that's what it's
hold on,
worth
Counselor.
now.
Your position is a 20% share investor who has the role of general partner can keep the limited partnership that has a specific expiration date continuing infinitely.
Absolutely. That's exactly what the document says. And Mr. Roth testified that it was set up that. Thank you.
That's the only question I had.
No other
Okay, thank you
questions.
both for appearing. We appreciate your arguments and the cases are submitted. All right, item 20. Thank you. Yeah, see, it's worth showing up even if
It
you're
is,
not
yes.
endorsed. So other lawyers take note. Item 23, docket number 370170, Stephen M. Ryan, PLLC versus Chris T. Christensen. Attorney Ryan for plaintiff appellant is appearing remotely. Any minute now. Oh, we're here. We know that much.
Okay, state your name. Wait,
Better lighting.
yeah, he's here. Can you hear us?
I can hear someone.
Okay, there he is.
Mr. Ryan with us?
Yes, Your Honor, I'm here.
Okay. Oh, I have a view of your ceiling.
Wait a minute. You gotta put your face in there.
Your Honor, I'm arguing this from a hospital bed at home.
I see.
And I will be as brief as possible.
Okay.
This is a collection action where I believe this is the only client I have sued in 48 years of practicing law, but it's just too much money owed by somebody who has more than enough money to pay this, and therefore this suit was filed. First of all, Your Honor, I'd like to address opposing counsel's brief, where he accuses me of unethical conduct. He accuses me of disclosing secrets, although he doesn't say what the secrets are. I have an idea what he's talking about. As a matter of fact, I'm certain I know what he's talking about. The defendant in this action used to be a stockbroker when he was in business out in California, and in the 1980s he, he had his license revoked because of activities that he had undertaken in connection with the massive prudential base stock manipulations that went on during that decade. What I'd indicate, Your Honor, is that uh, number one, uh, disciplinary actions taken against registered representatives by the SEC are not secrets, as he puts it, secrets between him and his attorney. Uh, these types of actions are recorded by the SEC. I don't think they're kept for that long by the SEC, but there's a semi-government agency, and I forget the acronym for it, but it's cited in my brief.
FINRA.
Pardon me?
FINRA,
Yeah,
Financial Institution.
exactly. Yeah, they keep detailed records of the approximately 3,500 stockbrokers in this country from coast to coast. And I had mentioned in the brief below that the defendant in this action, Chris Christensen, had his his Series 7 registered representative license revoked by the SEC, and that is what he is claiming is a violation of the attorney-client privilege because he didn't want that known to the general public. Well, it's a matter of public information. All you have to do is write a letter to this semi-government agency, tell him the name of the stockbroker that you wish to get disciplinary information on, and they'll send it to you. And they keep records that are up to date and go back, I don't know how far, but they go back quite a ways.
Mr. Ryan, this is Judge Redford. Thank you
Pardon
for
me, Your Honor.
this is Judge Redford. Thank you for appearing. I hope whatever draws you to where you're at right now heals quickly. I would like to know why the services provided by you to the client, why is the client responsible? Why is the individual responsible as opposed to this being a relationship with the corporate entity? I think that's the critical issue. And how is that memorialized in writing? Because it's the
Your
adoption
Honor,
of debt by another.
yeah, I understand exactly the question that the court is asking. Um, I was at a law firm in Birmingham when Mr. Christensen and his corporation, the Advanced Strategies Group Inc., which was a Michigan corporation, when he operated out of Michigan. He has since moved to Naples, Florida, and taken all of his operations with him. But when he was operating out of Michigan, I first met Mr. Christensen at this Birmingham, Michigan law firm. I left that law firm, and shortly after I left, I heard that that law firm had sued Mr. Christensen, actually had sued his corporation and him, and that the lawsuit did not end well for the law firm because Mr. Christensen asserted the corporate veil, and he was successful in defending that lawsuit. Shortly thereafter, Mr. Christensen came to me at my new law firm and wanted me to represent him and some of his companies. I said I would be glad to do it, but we had to have an agreement, and the agreement was there would be no personal guarantees by anyone of anyone's fees. It would just be a simple agreement that we would have that he, this Mr. Christensen, the defendant in this lawsuit, he would be liable, personally liable, for all fees incurred by him or by his company, the Advanced Strategies Group, Inc.
Is that memorialized in writing?
It wasn't memorialized by me, but it was memorialized by Mr. Christensen. And that is, I believe
Referring
it's,
to the email of the mid 2000s or 2010 or 8 or 12 or something, where he says, I wish I had the money to pay the bill, but I don't. I hope to get it to you next year. Is words to that effect. Is that the email you're referring to?
yes,
Is
Your Honor,
that the written
that is,
memorialization?
I'm sorry, Your Honor, that is what I refer to as a smoking gun email. He admits everything in that email that is needed in this cause of action to sue him individually. He admits that he owes the money. By the way, this email was written some 2.5 years after the Advanced Strategies Group was dissolved by law in Michigan. They didn't do the filings required by the state of Michigan for a domestic corporation, and so it was dissolved by law. And this email that Your Honor refers to, I believe it was dated in September of 2015, and that is I believe it's 2.5 years after the Advanced Strategies Group was dissolved by law by the state of Michigan. And in that email, Mr. Christensen uh, apologizes for not being able to send me money, but he tacitly admits that the invoices that were sent to him, and all the invoices are attached as exhibits to my brief for this matter. But he admits that tacitly admits that that those invoices are, number one, correct, and that they are due and owing by him. Now, in his response, he tries to say, well, that's just the way I talk. I was really talking about corporate debt, and I was really talking about monies owed by the corporation, the Advanced Strategies Group, to Mr. Ryan. But unfortunately for Mr. Christensen, that is not what that email says. That email says that he is going to pay it, that he owes it, and it tacitly admits that the amount is correct and it's due and owing. And there's no way of getting around what that email states. That email is what I refer to in my brief, as I stated previously, as the smoking gun email. I did not memorialize our agreement when he came to me after we had both left the Birmingham firm. I didn't memorialize that in writing. I should have, I didn't. But Mr. Christensen did me a great favor by memorializing it in writing by party admissions. These are all
Mr.
party admissions that
Mr.
he
Ryan, I'm not sure why, this is Judge Godola, if he volunteered to pay a bill, an invoice sent to ASG, and he volunteered in the email to pay the bill to ASG, that makes him legally liable for the debts of ASG. You know, all he says is, I can't pay it. How does that bind him legally? You know, maybe he's just doing that as a volunteer because there was no personal guarantee as far as I can see.
Well, Your Honor, there were no allegations in my complaint about any person or any corporation or anything else guaranteeing personally the debt of another. It doesn't exist in this case because the agreement that I had with Mr. Christensen when I took him on as a client after he had successfully avoided paying the attorney's fees to the Birmingham firm, what we agreed to was whatever legal fees were incurred by the Advanced Strategies Group, Inc., a Michigan corporation, and or by him personally, that is by Mr. Christensen personally, they would be paid by Mr. Christensen. Period. End of discussion. No personal guarantees by anybody of any other debt. he would be responsible for all of those. Now, it was never reduced to writing by me. It should have been, but it wasn't. I've been practicing law for 48 years, and I still don't have a will and trust. I mean, it's just the way a lot of attorneys practice law. They put themselves last when they stack them up against all of their other clients. That's exactly what happened here. But in September of 2015, Mr. Christensen did me a great favor. And when I represented him, he used to do this all the time. He used to confer with people, and believe me, he was involved in a lot of litigation. But he would contact the other parties, even the other attorneys, when I would instruct him not to do so, and he would correspond with them. Well, that's what he did here. And this is now the smoking gun that is hanging him on being liable for all of these attorney's fees.
Okay, Mr. Ryan, I think we have a firm understanding of your argument. Unless there are any questions remaining, you will have time for rebuttal. Is there anything else you feel compelled to tell us at this time?
Well, no, Your Honor, the oral agreement, I've addressed the allegations of unethical behavior by me, which are just utter nonsense. Because the only thing I disclosed were things that were already a matter of public record.
Okay.
And finally, Your Honor, I think that I would just like to say that I would like to thank the court. I've had a very severe downturn in my health in the last 3 or 4 years, and I applied for and received numerous, and I do mean numerous, extensions to file my brief in this matter. And I just made it in under the deadline, and I would like to thank the court for the extra time that the court allowed me to do this brief. Because I'm representing my own PLLC, and all of that time, I believe up to the last day, was utilized. And for that, I'd like to thank the court. Other
Okay.
than that,
Thank you, Mr. Ryan. You will have time for rebuttal. We'll hear from your opposing counsel now.
Good morning, or maybe good afternoon, Justices. Joseph Ahern appearing on behalf of the appellee, Chris Christensen. Just real briefly, the trial court got it right. This is a 2-count complaint, count stated, and sued on open account. And she basically held that you can't have these counts if you're not providing services for the defendant, which was Mr. Christensen. And I see the court's questions are the same. There's been an admission in this case that the vast majority, perhaps high 90% of these services were for the corporation. And in fact, in the 6 years of this lawsuit, we haven't been pointed out to a single time entry that was for Mr. Christensen personally. So the court said, based on those circumstances, we have to dismiss the complaint. The court then discussed what I think is the real issue in the case and the real claim, which is this personal guarantee. And I think your questions are the same as ours. Where is this must be in writing, must be very explicit personal guarantee? There is none. And I think the 2015 smoking gun is not sufficient. So that's all I have to say in this, Your Honor, or Your Honors. Also, as far as the unethical behavior, that's not up before us. I think we just pointed in our brief because it was brought up. The court decided they didn't need to go there, and we didn't cross appeal on this one. So we really don't have to consider it.
Okay. Any questions for Mr. Earnhardt?
No.
Okay. Thank you.
Thank you.
Mr. Ryan, any rebuttal?
no, Your Honor, I have no rebuttal.
Very good. Thank you very much, Mr. Ryan in particular, for going to great lengths to be with us today. We wish you a speedy recovery to full health. And with that, the case is submitted. Thank you for your arguments.
Appreciate that, Your Honor.
Thank you. Thank you. All right. That brings us to item 25, which is our last case of our call. Docket number 370653. Estate of Ernestine Davis versus Ascension Providence Hospital.
Good morning, Kirsten Reinhold on behalf of plaintiff appellant, the estate. We are asking this court to reverse the trial court's order granting summary disposition for two main reasons. First, there remains a genuine issue of material fact on causation. We disagree that the expert testimony was speculative in this case. And for the second reason, that the trial court failed to review the evidence in the light most favorable to plaintiff as the non-moving party. There is a logical sequence of events from Dr. Abbas's breach of the standard of care to Ernestine Davis's ultimate preventable death, that we would say under Rodriguez, there is sufficient evidence established by the expert testimony from which a jury can hear that, review it, and come to the inference that defendant's negligence caused the ultimate injury. And since there's so much deposition testimony and factual evidence, I don't want to rehash that with you since you've already read it multiple times, I'm sure. So I would yield my time at that point unless you have questions for me on this.
Any questions for counsel?
No.
Not at this point. You'll have time for rebuttal.
Thank you very much.
Counsel.
Good afternoon, Amy Schlaughter appearing on behalf of Appellee Independent Emergency Physicians and Dr. Abbas. I have all my papers with me, but I guess I don't have to bring them up here because maybe this will be short. I believe that the trial court got it correct. So one, I'm not certain in terms of the argument that the court did not view the facts in the light most favorable to the non-moving party. The court did an analysis, issued an opinion, did go through all of the evidence. I just want to briefly state a few things for the record. So in this case, there are two standard of care criticisms as to my client. I'm representing both IEP as well as Dr. Abbas, but there are no independent allegations of negligence as to independent emergency physicians. The allegations and the questions are the alleged breaches of the standard of care of Dr. Abbas, who's an emergency medicine physician. The only physician who's qualified to testify as to breaches of the standard of care on behalf of the plaintiff appellant is Dr. Janiak, who had two standard of care criticisms. He alleged that Dr. Abbas should have called a code stroke and that she should have ordered a brain CTA. All other standard of care criticisms raised by Dr. Janiak in his affidavit of meritorious claim were waived by him at his deposition.
Standard of care wasn't really the basis of the trial court's ruling. It was proximate cause. So
I'm jumping to, I apologize, Judge Goodall, I promise I'm going to move right there.
Okay.
Plaintiff's attorney just said that there was ample evidence to establish causation and standard of care. So I want to address the two standard of care criticisms because the question before you is whether or not the court was correct in finding that plaintiff could not establish causation. It's not causation at all. It's not whether or not plaintiff has evidence, and plaintiff had other defendants that they raised arguments as to. It's whether or not the two standard of care criticisms as to my client plaintiff can establish the required but-for causation. So the two allegations as to my client are failing to call a code stroke, whatever that might mean, and not getting a CTA. So I want to move on to those two things. Has plaintiff appellant established that there's a question of fact as to whether or not there is expert testimony to establish that but for the failure to call a code stroke, and but for the failure to order a CTA when the patient was in the emergency department, that would have changed the outcome. That's the issue here. And we go through painstakingly the deposition testimony. And I will try to be very brief because appellant's attorney was, but I don't know what she might say in her reply or rebuttal. So I want to make sure to get a couple of things out. The two causation experts that are identified in the appellant's brief are the neurointerventionalist, Dr. Zawarski, and the interventional neurologist, Dr. Venkat Subramanian, often referred to as Dr. Venkat. Dr. Zawarski, and we go through this in our brief, Dr. Zawarski states that even if a CTA had been ordered while the patient was in the emergency department, that the patient still would have been placed under intervention. Dr. Zawarski does not say that had a CTA been ordered by my client, an intervention would have occurred. I'm citing, it's in the appendix, his deposition testimony. It's pages 51, line 13 through 52, line 1. Dr. Zawarski and Dr. Venkat both state that the time period for an intervention is not when the patient was in the emergency department, and they agree that the patient would not have gotten an intervention, even if a CTA had been ordered. Dr. Venkat goes on to describe the fact that when an MRI of the brain was obtained the day after the patient left the emergency department, she still had good collaterals and was not a candidate for any type of intervention. What the trial court agreed with me on, and why the trial court dismissed my client, is because plaintiff's causation experts say the time window and when they believe an intervention was required is when there was a change in the patient's condition on May 11th, which is approximately 24 hours after she left the emergency department, and that window of time to do an intervention and to get additional testing was between May 11th and May 13th. A
There's
CTA
testimony of record, counsel, from some licensed medical professional that while the patient was oriented to the three spheres, and these are my words, not theirs, when the patient was first admitted, that because some 8 to 12 hours later, there was this dramatic change that someone has said at that point, there had to have been a massive cerebral vascular accident. And again, my words, I'm not quoting depositions. And that somebody has said, who's a licensed medical provider, that had steps been taken to put her in a more active observation state of affairs when she was first admitted to the emergency room, they would have identified that right away. The new event would have been the massive CVA that eventually caused her to lose her life. Does anybody say anything close to that?
So no.
Okay.
And so that's the issue. So the issue is that when the patient is admitted, she goes from a NIH stroke scale of 1 to 28 the next day.
Right.
That is the clock that starts. And plaintiffs' experts have said that is the large stroke that then
28.
starts the clock for when you need to do an intervention, which is when she's no longer under my care. I will say that Dr. Venkat indicated that she's not a standard care expert, but that a CTA should have been ordered. Dr. Zawarski testified that the CTA would have shown that she needed to continue to be monitored. And Dr. Venkat, when she was pressed, acknowledged that the MRI of the brain showed that she did have good collaterals. I think where the plaintiff's case falls apart is both Dr. Venkat and Dr. Zawarski say that this time window for doing an intervention is not in the emergency department. Everything the patient had in the emergency department would not get an intervention. Once there's a change, that's when the time window starts, when she's an inpatient. And that any time between May 11th, when there's a change in the patient's condition and the NIH stroke scale goes from 1 to 28, that's the start time. And that any time between then and when the patient's blood pressure dropped on the 13th, that the patient should have had an intervention. And anytime during that 48 hours.
So I want to follow up on Judge Redford's question. And I will read some of the deposition testimony because I'm not sure I agree with your characterization of Dr. Venkat's testimony. Dr. Venkat testified that if Davis had a CT angiogram or MR angiogram, quote, when she presented on the 10th, quote, either one would have demonstrated that she had a segment of her left MCA that was occluded, but it also would have shown that she had distal flow and collaterals. And then she went on to testify about what the proper course of action should have been. She opined that on April 10th, Davis required the medical management she described, which was not provided. This is on the 10th, not the 11th. And she opined that if Davis's stroke were properly treated, she would not have died. Why isn't that enough to survive summary disposition?
Well, because the proper treatment then gets parsed out because Dr. Venkat is a causation expert in terms of the proper treatment. There's more.
It's an issue for trial, isn't it?
Well, there's more questions than answers. And first of all, Dr. Venkat cannot testify as the standard of care of Dr. Abbas. So Dr. Venkat did go out on a limb with other things that she thinks the standard require of Dr. Abbas, but she can't testify to. And I think that there's a generalization for Dr. Venkat, but when you actually, the trial court, and I know this court will do a de novo review, but there's a gatekeeper function and there's a requirement that we drill down on what the experts are saying needed to be done. Dr. Venkat goes on to say that even on the 11th, the patient had good collaterals and good perfusion. That's at page 45 of her deposition testimony. Dr. Venkat agreed that an intervention is not required in the emergency department, even if the patient had had a code stroke, even if a CTA had been ordered, no intervention when the patient was in the emergency department. That's her deposition, page 26, line 16 through 27, line 14. I'm not trying to mislead the court that Dr. Venkat, a very good advocate for the plaintiffs, said, I think the patient's overall condition deteriorated, and I think that the patient would have survived the stroke. But when we drill down on what's the time period that they're saying an intervention was required, it's between the 11th and the 13th when this patient was no longer in my care.
Any other questions for
I
counsel?
understand the positions.
Okay,
Thank you very
thank you.
much.
Thank you.
Rebuttal.
I have a trial starting next week, counsel, and I have about, I don't know, 15 binders that size that the lawyers have given me. I've been complaining to my colleagues, not complaining.
Yes, he is.
Okay, I've been talking about it.
Really need us to print out everything. I said I do, because I don't know what they're going to ask me about.
The chief judge goes, who needs binders? Why are you asking people to do binders?
We don't have that in the
Redford?
budget.
So I would like to say that I think a critical part of this is that intervention is not necessarily just a surgery. I think we're getting a little bit caught on this thrombectomy. That's what we're usually talking about when we're talking about a mechanical intervention. But Dr. Venkat also discussed that there was so much more that would have and could have been done if the testing and the code stroke had been called while under Dr. Abbas's care.
On the 10th.
On the 10th,
emergency.
in the emergency
So can you
department.
point us to the testimony where Dr. Venkat said that those interventions or interventions, maybe or monitoring,
Oh, yes. I
should have taken place by order of Dr. Abbas?
So I have a couple different places where, so I don't have the exact quotations in here, but I do
Sure.
have her deposition, page 33. She's talking about the processes that the brain is undergoing. She talks a lot about the code stroke. This would be page 26 of her deposition. I believe that would be my appendix, page 202. She discusses the difference in the interventions that would have been occurring. So it's not just about, can we perform a surgery? It's about, she should have been, while she was still in the emergency department, the CTA should have been performed. And while she was there, if that had been performed, they would have discovered almost, I believe, 30 to 32 hours early, this blood clot in the brain and this reliance on the collaterals. And then in addition, calling a code stroke instead of referring her to medical or surgery would have resulted in different treatments that are not necessarily surgical, but things like monitoring hydration. It was actually her surgery referral, medical referral people who provided her with blood pressure lowering medications, which was actually detrimental to her. She actually should have had permissively high blood pressure, according to Dr. Venkat, because she's relying on collaterals rather than a main artery. So she needs high hydration. She needs high blood pressure in order to continue to get that blood flow where it needs to go in the brain, to not suffer these subsequent strokes that are causing additional neurological damage, because she only came in with a facial droop from her original stroke. These later strokes could have been prevented if we had gotten everything done correctly in the emergency department.
Do you want to drop a footnote at all about the issue of standard of care and the ability of Dr. Venkat and Dr. Abbas to provide that testimony here? Because it's been talked about.
Yeah, so I don't feel that Dr. Venkat has testified about a standard of care relevant to Dr. Abbas. I believe for our purposes, she has been purely a causation expert regarding Dr. Abbas. But I will say also, she is a neurologist, so she can speak to what a code stroke team would have been able to do because there would have been neurologists and neurointerventionalists. So she could, put herself in those shoes and say, this is what would have been done had we been doing the proper treatments.
Thank you.
If there are no further questions.
Any other questions? All right.
All right,
I
thank
don't
you so
think
much.
Nicely argued. We appreciate your
Yes,
arguments and your
appreciate
appearance.
being
Thanks
here.
for lugging the huge binder
Yeah.
all this way.
I hope you
Really
have a
didn't need it.
rolling bag.
You bet. Case is submitted, and with that, we are adjourned.